Permitted uses and disclosures is an important HIPAA topic, so thanks for joining me today. HIPAA is found in the Code of Federal Regulations 45 CFR. Permitted uses and disclosures is found in part of 164.506C2, which governs how covered entities, CEs, and business associates, BAs, are required to protect and secure protected health information. This compliance tip discusses a few of the circumstances where your organization may be permitted to disclose PHI without obtaining written permission from the patient, such as for treatment and healthcare operations. Check your state privacy laws and always follow the most restrictive rule. Covered entities should share treatment information for the management of healthcare and related services. This includes the coordination or management of care by a provider with a third-party consultation between treating providers of the patient and when there is a referral of a patient for care from one provider to another. All this may be done according to HIPAA under permitted uses and disclosures. When providers share a patient in common and this rule applies, an illustration of how this rule works looks like the image on this slide. Transfer of ePHI requires compliance to the HIPAA security rules. To develop the plan, the BA requests pertinent PHI about the patient from the patient's other providers, such as hospitals the patients have been admitted to for the same or similar medical care, and the patient's health plans. Each of these covered entities may disclose the relevant PHI for care planning purposes. Using certified electronic health record technology, CEHRT, or other electronic means. In this scenario, a business associates agreement, or BAA, is only required between the covered entity that hires the BA and the BA. The responding covered entities may make permissible disclosures directly to the provider's BA for the provider's care planning purposes, without the need to execute their own BAA with the care planning company, just as they could share this information directly with the provider. Under HIPAA, the patient's other providers and health plans which have sent PHI to the initial treating provider's BA are not responsible for what the BA does with the PHI once it has been disclosed permissibly and securely. When a hospital or other inpatient facility is preparing to discharge a patient who will need ongoing facility-based care, the inpatient facility, patient, and patient's family will need to identify a new facility to accept the patient, and the prospective rehabilitation facilities will need protected health information about the needs of the patient to determine whether they can provide appropriate care. The inpatient facility is responsible for complying with HIPAA and disclosing the PHI to the rehabilitation facility, which includes sending the PHI securely and taking reasonable steps to send it to the right recipient. After the rehabilitation facility has received the PHI in accordance with HIPAA, the rehabilitation facility, as a CE itself, is responsible for safeguarding the PHI and otherwise complying with HIPAA, including with respect to any breaches that occur. The sending provider, CE, in this scenario would not be responsible for the PHI once it has been received. The information in this compliance tip video and all AIHC compliance tip videos is not intended as legal or consulting advice. The information provided in these brief tips is not exhaustive, and you are encouraged to seek additional information to supplement the information contained herein. Thank you for joining me today for the HIPAA compliance tip. Consider additional professional HIPAA training through our organization. We offer annual staff training, release of information training, and comprehensive privacy and security compliance officer programs. Visit our website for more information.